All right, good afternoon, everyone. I'm Professor Raymond Koo, co-director of the Center for Law, Technology, and the Arts here at Case Western Reserve University School of Law, and so I'd like to welcome you here this afternoon. It's my distinct pleasure and honor to introduce Daniel Solove as our distinguished lecturer here in our Law and Technology program. Dan is an associate professor of law at George Washington University. He is a Phi Beta Kappa graduate of Washington University, where he majored in English literature, and a graduate of Yale Law School, where he was the recipient of the Field Prize. I've known Dan since he started at Seton Hall University School of Law, where I started as well, and he has been, in a very short time, kind of a star in the privacy field, as many of you may already be familiar with his works. He is an internationally known expert, as I just suggested, in information privacy law. He's a frequent commentator both in terms of national media, the press, as well as an expert in all sorts of informational privacy litigation matters. He's the kind of definition of prolific author, with over 25 law reviews and essay articles to his name at his age, as well as the author of a handful of and a growing number of books, of which The Future of Reputation, Gossip, Rumor, and Privacy on the Internet is just one. And so he's going to share some thoughts with us that stem from this book, as well as his other work with us today. And so join me in welcoming Dan here to Case Western.
Thank you so much for having me here today and for being here with me to talk about some of the ideas in my new book, The Future of Reputation. Now, basically what the book is about, it's about how gossip and shame and reputation are being transformed by the Internet in ways that will have profound implications for the future of our society. Now, I became interested in this topic when I began blogging back in May of 2005. This is my current blog. It's called Concurring Opinions, and I started blogging here, and in a short while, more and more people started reading, and today I'm fortunate that I have several other co-bloggers, and we're read by thousands of readers a day. And I was really excited if I wrote something interesting, people actually seemed to read it. I saw people linking to it and talking about it and discussing it and commenting it, which is exciting for an academic that like anybody reads anything. So I really found this to be an amazing experience, and I loved it. This is an example of my site meter. This tracks the daily traffic of my blog, and you'll see here on the bottom there are days of the month, and you'll see these big spikes. That's what happens when a very, very popular blog will link to a post at our blog, and you'll see the numbers of visitors skyrocket as high as 11,000 on one day. There are blogs actually that get over 11,000 visitors in a day. So we're not quite at that level, but when they link to us, we get a lot of traffic. And so I really find these experiences quite dazzling, quite amazing. And one thing that I like about blogging is that before I started blogging, I used to try my hand at some op-eds. I'd read about a privacy case or a case involving criminal procedure, and I'd write off what I thought was an interesting op-ed, and I'd submit it to a bunch of papers, and then this would happen. And so I kept doing this, and after doing this so many times and wasting so many afternoons, I'm now delighted to say I don't need the op-ed papers to get my works published. I just write it on my blog, and I type it out on a screen that looks like this. I put it into this little box here. I change it to publish, press the save button. Presto, it goes out to the entire world where anybody can read it, access it, comment on it, share the link, and so on. Now, in the 15th century, there was a revolution in the distribution of information, and this occurred through something called movable type, the printing press. You'd set letters into position, you'd press, and this was an amazing development in the history of media because this was the first time that you could mass produce manuscripts, papers, articles. And what we have today is a different kind of movable type. I think it's no accident that the software that I'm using for blogging is called Movable Type. This is a blogging software. This is the software that I use to post things to my blog. And what is amazing here is that it allows anybody with an internet connection, with very hardly any resources at all, to reach a worldwide audience if they want, to publish to the world without the power of the mainstream media to do that. The blogosphere is growing dramatically. This is a chart by a site called Technorati, and it charts the growth of blogs. Several years ago, there were only about 50 blogs. Today, there are over 50 million blogs. Now, I think that these developments are amazing. We have internet chat rooms, we have social network websites, we have blogs, we have all these things where people are expressing themselves and having discussions and debate. And I think this is a great thing for freedom and self-realization, that anybody can reach out so far and wide with their thoughts. However, there's a dark side to the story. There's always a dark side, and there's a dark side to this, and that is what my book is about. It's about the good and the bad, but in particular, I'm focusing on one of the problems with these developments. So I begin the book with someone who is known as the dog poop girl. She's actually very, very famous. Millions of people from around the world know her. She's an international celebrity now. The story begins in South Korea on a subway train. A young woman is on the train, and she has a little dog with her. The dog has to go to the bathroom. It goes on the train, and she's in a hurry. She doesn't clean up after the dog. She walks off the train. Well, someone is not very, very happy about it, and they decide, we're going to get her back. And so they reach out with their cell phone camera and take her picture. They upload it online, and all of a sudden, everyone starts writing in, attacking her, adding and annotating it with personal information. They start making, this is a picture that they make, one of the things with some of the pictures of this, posting this around. They Photoshop this and create all kinds of posters mocking her, attacking her, and whatever. And this also extends to her own life in real space, because they put contact information about her. They say how you can reach her and who she is and who her friends and family are. In addition, this goes worldwide, in fact. The papers start reporting on it. It gets blogged about in the United States and then picked up by several popular blogs. It gets picked up by the Washington Post. Everyone. The Washington Post is writing a full-length story about a girl whose dog pooped on the internet, on the subway. I mean, I don't know what this says about the mainstream media, but this person is now very, very well known. In fact, a lot of blogs found the story fascinating. It was particularly popular at this site called Doggy News, and it was the story of the century at the blog called Poop Report, where you don't want to look around the rest of this blog. This is just one example of how the internet is changing our way of life. People used to shame each other by giving angry glances or by telling them off, but now the internet allows a cyber posse to gather around the world and mete out justice online. And forever, this woman is going to be preserved on the internet and known as the dog poop girl. So I think that life today in the digital age is presenting us with a little bit of a paradox, and that is that information flows freely. It's enhancing our freedom and autonomy, but at the same time, I think it's making us less free. And how and why is this happening? How could more information, how could all this ability to speak be making us less free? Well, my co-bloggers and I, we blog about the law and occasionally other topics, and there are blogs that blog about political issues and current events, but this is just a fraction of the blogosphere. A very large number of blogs consist of people talking about their own personal lives. This is a diary, and this is something that people used to write their own personal lives and their stories, and they'd write it, and they sometimes would come with locks on them, and they'd be stuck in, hidden away in drawers. Well, let me tell you, diaries are so 20th century, because today, people are using the computer as their diary. They're pouring their thoughts onto social network websites and blogs. And they're not just spilling out their own secrets, they're spilling out details about their families, their friends, their enemies, their coworkers, their bosses, their teachers, which I really don't like, their students, they're actually professors who blog about their students, and many, many more. Well, when I was in high school and college, I didn't have my own website. I didn't have a blog. There was nothing like MySpace or Facebook. I owned a computer that looked like this. And I looked like this. Now, the generation growing up today, the generation that's in high school, the generation that's in college, they all have blogs and social network websites. There's many different kinds of social network websites and other sites where people can have conversations, create profiles, and have blogs on them as well. And these are the rage. The percentages of people using these sites is astronomical. And blogs and social network websites are becoming immensely popular with user-generated content. One statistic is that 65,000 videos are uploaded every day to YouTube, a site where people can share their own videos. There's also profiles at one of the most popular sites for social network websites, 100 million profiles on MySpace. That's a lot of profiles. And that's just one of the social networking websites. There's also Facebook, which is growing at astronomical rates. Well, who is doing all this? Who are all these people? And the answer is, I think, captured by this cartoon. The cartoon says, well, yes, we could read your blog, or you could just tell us about your school day. Well, the point of this cartoon is that the people blogging are young. According to one statistic, over 50% of the people blogging are under the age of 19. Now, I want you to close your eyes, and for those of you who, well, you're all now out of college and out of high school, but just close your eyes and imagine all the gossip and rumor that was swirling about in your high school days and your college days. Now, also imagine all the things you want other people to forget. And you can relax now, because it's probably forgotten. And that's because it's stored on this device. Well, today, for the people who are in high school and college, they've got this thing, something called Google, and suppose you want to find out more about me or about a friend or a family member, well, just type your name into Google and press search, and presto, you're going to get a whole list of various information fragments about other people. And people are Googling all the time. They're Googling each other. They're Googling friends, dates, potential employees, long-lost relatives. Employers are increasingly doing Google searches on prospective employees. We're witnessing what I call Generation Google, which is this generation that has all these fragments of information about them on social network websites, on blogs, and other sites, and they're going to be forced to live with a detailed record, beginning with childhood, that's going to stay with them for the rest of their lives, that's going to be searchable and accessible from anywhere in the world. But let me tell you another story, and this is a story of someone who became known as the Star Wars Kid. Star Wars Kid is a 15-year-old kid from Canada, and he's not the most popular kid in school, and he films himself waving around a golf ball retriever, pretending like it's a lightsaber. and he's making noises, and he's stumbling about. He doesn't have the benefit of George Lucas directing him and the great choreographers, so it's humorous. And, well, he films this. He has no intention of putting it online, but some of his enemies find this video. They stick it up on a site where anyone can download it for free, and people start downloading it. In fact, many people start downloading it. Millions of people, tens of millions of people, in fact, start downloading it. And people start writing about it all across the blogosphere. People are talking about this, commenting, making fun of this kid, mocking him, laughing at him, and so on. Some people thought, well, let's add special effects to the video. And so they made the lightsaber glow. They added Star Wars music. They have the videos open where you have the opening description where the Star Wars lettering flies across the screen in the universe. They also added that. And more, in fact. What they've also done is created mashup videos. This is a search of Star Wars Kid on YouTube. And these are just a handful, I couldn't even fit them all on this screen, of the various versions of the Star Wars Kid video. You want to watch it mashed up with The Matrix? Guess what? You can. You can see many different kinds of this video, and it's become immensely popular all around the Internet. And so now imagine this poor kid. Imagine it's hard enough to be teased and tormented in your high school days, but imagine being teased by tens of millions of people around the world. If you search under this kid's real name, you'll come up with a Wikipedia entry for him that's the Star Wars Kid. So forever this kid is known as the Star Wars Kid, and that's going to be his claim to fame. Now, we're going to see this more and more because there's cameras everywhere. It's so easy to capture information about our daily lives, and this is only going to increase as the technology gets better and better. We're all now walking around with little cameras in our phones. Well, soon we're going to have videos that we can run. And now you can even record short videos with your phones. Well, maybe you'll be able to record longer videos. Soon people will be recording 24/7 everywhere they go, and so on. And so this prompted, a while back, Scott McNealy, the CEO of Sun Microsystems, had this very famous quip. He said, "You already have zero privacy. Get over it." Should we get over it? Perhaps generations in the future won't expect privacy. Perhaps we'll live in a future where we can finally be uninhibited and honest because everyone's warts are going to be exposed. And therefore, maybe people will stop readily condemning each other. Maybe people's judgment will have less hypocrisy. But there's an alternative vision of the future. And maybe that's one where we're going to be less free. Maybe that's one where people's reputations could be ruined in an instant. Maybe that's one where people's past mistakes can thwart one's future opportunities. I think we're starting to see the future of reputation. Reputation plays an essential role in our society. We look to people's reputations to decide whether to trust them, whether to do business with them, whether to engage in commercial transactions, and so on. And it's how people in society hold us accountable to each other. And to assess reputation, we need information about other people. Now, in earlier times, people used to live in small villages, and they had firsthand knowledge of each other. And today, we live in a much larger, more mobile, more impersonal society. I think the Internet's bringing back some of these features of the small village, but with a twist. In the small village, people had a long history together and knew the whole story about each other. But now, people don't often know the whole story. All we have are fragments of information, often a mixture of fact and fiction. Now, when little is invested in a personal relationship, even information that's incomplete or dubious might be enough to shun and ignore people. And I think that's a problem. Now, another problem that we're seeing is gossip online. According to one study, 2/3 of all conversations involve some form of gossip. And in the past, gossip has traveled in local circles, and it rarely spread widely. I mean, people outside your school or your workplace wouldn't really care about the gossip in your particular location or the particular place that you were, and it would be forgotten over time. But with the internet, when gossip moves online, it's no longer localized and it's no longer fleeting. An example of a case that happened a few years ago is known as the Washingtonian case. This is a case that began when a young woman named Jessica Cutler, who was a young employee at a U.S. Senator's office, decided to start a blog. And she started blogging about her personal life and about her dating life and also about her sex life. And she had a number of partners. She was going out with 6 different guys at different points. And the large focus of the blog was on a relationship that she was having with another person who was also working for the senator, an attorney who worked for that senator. And she blogged in explicit detail about their sex life, including facts about spanking and other things that they would do. And this got linked to by a blog called Wonket. Wonket is a very popular political gossip blog, and when it got linked to by Wonket, it got a ton of traffic. Everyone starts reading it. Everyone starts writing about it. The Washington Post magazine writes a story about it. The New York Times, all the major media jump in and write about this, and so this becomes all over the place. And Cutler, she revels in it. She lands a Playboy deal, and she also gets a 6-figure book deal worth purportedly $300,000 advance to write a book called The Washingtonian, named after her blog. Well, while she was getting all this publicity and liked the new fame that she was getting, the guy who she was dating and wrote about was not particularly pleased at having his sex life emblazoned across all these different sources, and he sued her for violating his privacy. Currently, the suit has been stayed. Cutler has declared bankruptcy, and so at this point, the suit is not going forward, and I don't know what's going to happen to it, but that's where that case is. And it's the transformation of gossip into something indelible, something widespread and widely accessible. Is this problematic? Well, for centuries, societies have been engaging in gossip to determine whom to trust. And maybe we should celebrate having more information about people's lives. Maybe we should be happy that people can't hide discreditable secrets about us. We'll be able to Google them and really find out much more about them. Because some of the mottos of the information age are that information wants to be free and that more information is better. These are the mantras of the information age, the common wisdom that I often hear about it, these libertarian norms about free-flowing information. And maybe, as some contend, having that information will help us make better judgments about each other. More information is going to be better. But information taken out of context can lead to hasty and unfair judgments, I think, that often don't lead to more truth about a person's character. I think that, ironically, these libertarian norms of the Internet and of the information age can actually lead to a world of greater oppressive control. It could enslave ourselves to our past mistakes, and I think that could be a serious problem for freedom. Well, beyond gossip, the Internet's also transforming the practice of shaming. Every society has its rituals of shaming. We give angry glares. We tell people off. We try to signal that we're displeased with things that people do that are rude or that violate a norm. This is, though, on the Internet, as this becomes a tool to shame other people, I think it starts to create problems. Now, the dog poop girl. Let's go back to the dog poop girl. It's very clear that she violated a norm. I don't think anyone thinks that her behavior is a good thing. You should clean up after your dog. Everyone, I think, would ascribe to that norm as the proper behavior. And so I think she did violate a norm, and I think that someone should tell her that she was incredibly rude. She should be punished for what she did. But has she been punished too harshly? Have we brought back the Scarlet Letter? Nathaniel Hawthorne wrote the book The Scarlet Letter, where Hester Prynne is forced to wear a Scarlet Letter A for adultery. And are we creating the digital equivalent to the Scarlet Letter, where forever she's going to be branded as the dog poop girl, and it's never going to end? Well, there are websites that are actually starting to systematize shaming. There's a website where you can shame people for being a bad tipper. There's another website called Don't Date Him Girl. And this is a website that allows vindictive exes to post about their boyfriends whom they've dated who they are not particularly happy with. And they're posted under these folks' real names. You can do searches for them and so on. And one of the things is that one of the reasons why people shame each other is that we shame because we want to enforce norms and we want to promote greater social control. And indeed, we see a lot of rude behavior in this world. And so, shaming is an important thing. But I think norms can be oppressive. And I think that internet shaming often turns into mob justice. It often careens out of control because there's no limit. There's no one to say, this is a proper thing to shame somebody for, and this is not a proper thing to shame somebody for. There's no due process on the internet. What if they're wrong? There's there's no sense of proportionality. There's no way people can stop. There's no one to tell them to stop. And so I think paradoxically, shaming, which is a tool to help maintain social order, in fact becomes something that subverts social order when it goes online. Well, I've talked about shaming, I've talked about gossip, I've talked about all this information that's going online and how it can harm people. But is there anything that we can do about it? Is there anything the law can do to help us out of this problem? And I suggest there are sort of three broad paths the law can take. And I want to sort of take us through the different paths, which one I think is the best one, and ultimately some more specific things that I can suggest that we can do here. Well, the three paths are what I call the first is the libertarian approach, which is hands-off. It's best to keep the law out of it. The law is clunky. It's going to be too restrictive of speech if it gets involved. We should let things develop as they should do and stay out of it. The problem is that people really care about their reputations. And if we have the law do nothing, people might start to try to do something themselves. In other societies, before we really had good law to protect us against things like defamation, to protect our reputation from invasions of privacy, people resorted to dueling to do that. Now, we've ended dueling, and the law has replaced dueling as the way that people try to vindicate their reputations. But people will try to find some outlet to vindicate their reputations because it matters. It matters for their future and for how they're perceived by others and for their job opportunities. And so I think that just doing nothing is not really a solution. So I reject the libertarian approach. On the other hand, I think that another approach is the authoritarian approach, which I think is equally bad. And that is, we're seeing a lot of proposals by legislatures. Every time there's a case where someone is bullied in cyberspace or something really bad happens, we see these attempts to pass laws that ban like all anonymous speech online, or that try to restrict social network websites, or mandatory ID for being able to sign up for a social network website. I think a lot of these solutions are way too overkill. I don't think they're very effective. And I ultimately think that they are stifling and oppressive of speech. This is something also that I don't think is going to fly with the First Amendment. So a lot of these solutions, I think, are typically vague and overbroad and run into First Amendment problems. So I think that the authoritarian approach, I think, is flawed. And so ultimately, I come out into the middle ground, a position that probably no one likes and that is not particularly an exciting, fun place to be. But ultimately, we're dealing with a situation where we have two very important values in conflict: privacy and free speech. And I think we have to be very careful not to push one or the other too hard, or else we start to, I think, denigrate a very important value. And they're both very important. I think that in a middle ground approach, what I recommend is invigorating the privacy torts. We already have a set of torts that can help us protect people's privacy. They arose from a 1890 article by Samuel Warren and Louis Brandeis. Louis Brandeis later went on to become a Supreme Court justice. And most states now recognize the majority of the privacy torts. There are 4 of them. And there are several that allow people that could potentially apply to online speech, to online attempts to invade people's privacy. But the problem is that the torts are very weak. They're extremely weak, and they're not very effective at protecting people. And so I think that we should strengthen the privacy torts. But I also don't think that having a lot of lawsuits is the answer. So ultimately what I try to do is suggest that we strengthen the torts, but we take away some of the bite of the torts so that they're not as that there's not a rush to the courthouse to sue everybody. But the torts serve as a credible threat so that people realize that if they're going to blog, if they're going to write about each other online, they've got to be careful because there could be consequences. So I kind of want lawsuits to kind of be hovering around, but I don't really want them to materialize in most cases. But one of the problems with the law is that it's been held back by antiquated conceptions of privacy. And so I think what we see in the law is that the law overprotects speech and underprotects privacy. The balance between speech and privacy that the law currently has is out of whack. And so I think we need to help push up the privacy side a bit. And to do that, I think the thing that the core of the problem is that we have understandings of privacy that are not going to work well for the problem that we're facing. And so let me talk a bit about some of those, and then you sort of see how the torts might be reinvigorated. One of them is what I call the binary understanding of privacy. And this sort of is something that splits the world into two realms, public, private. And the idea here is that if you expose information to the public, or if you're in a public place, you don't have an expectation of privacy. You lose your privacy in that situation. And I think that that notion, that simplistic view, that basically the minute something gets exposed to the public, that it's over for privacy, is really flawed in today's world. Let me give you an example of why. Suppose you're at a drugstore and you're buying various medications and various hygiene products and other things, and there's a blogger who basically blogs about what people are buying at the drugstore. And they run around with a camera taking pictures of everybody's basket and then taking pictures of their face and posting it online and finding people who would identify these people and then saying, here's what you bought. Now, you're in public, but your expectation is that, yes, you're in public. Yes, the store clerk is going to see what you buy. Yes, other people in the store will catch a glimpse of you taking stuff off the shelves. But you don't expect them to be blogging about it. You don't expect an inventory of your contents. Just like when you're at a restaurant, you expect people to overhear snippets of your conversation, but you don't expect them to be recording every word and posting it online. So we do expect privacy in public. We do have a lot of expectations in public. It's just that they're different, but we have to understand a more nuanced view of privacy than this very simplistic public-private binary divide. Now, another understanding of privacy that I think is antiquated is that it's tantamount to secrecy. And the idea is this, that if you tell your friend your deepest secret, and your friend decides, this is blog fodder, and starts blogging about it, guess what? The law says, you're out of luck. You know, you trusted the wrong friend. You shouldn't have had that person as a friend. You made a poor judgment. Choose better friends. Now, if you tell your doctor a secret, your doctor can't say blog, like, cool, weird ailments my patients have. Your lawyer can't start saying, cool cases my clients are involved in, and here are their messes that I'm helping to clean up. You can't blog about that, and that's because it's understood that there's a implicit duty of confidentiality that the doctor has to the patient, that the lawyer has to the client. In England, they've rejected Warren and Brandeis's torts, but they've embraced a tort called breach of confidence. And this tort allows friends, family, ex-spouses, even lovers who divulge people's secrets to sue, to be sued if they divulge the secrets. And it's understood that when you tell someone, there's an implicit duty that you keep things confidential. And they also protect against doctors and lawyers and so on, too. Now, we have this tort in America. We have the basis of this tort here. It just never developed that way here. But there's nothing to suggest that it couldn't develop in the same way it developed in England. And so maybe the law should develop that way. And maybe that would help keep people to recognize that you just can't say whatever secrets you happen to know about your friends or others. There's another part of privacy, a third thing about privacy I want to talk about, and that's control. And I have a picture here of Dr. Laura Schlesinger. Dr. Laura is a very well-known conservative radio talk show host, and she espouses family values in a kind of very sort of sharp, no-nonsense way. Well, a while back there was an incident where an ex-lover of hers from 20 years ago had taken nude pictures of her. And he decides, I guess he needs some money, and sells them to a video voyeur website, which promptly posts them on the site. And she's, of course, outraged and very upset about this. And so she sues that website. And the website says, First Amendment, free speech. And the court says, sorry, you're not going very, very far on your privacy lawsuit, Dr. Laura. You lose. Now, other websites said, these pictures are great, and we want them for our voyeur websites. And so they start posting the pictures. Well, guess who gets angry now? The video voyeur website who originally bought the pictures. They say, these are our pictures. You shouldn't post those pictures on your sites. And they sue. And guess who wins? They win. And the head of this video voyeur company even said, you know what? If Dr. Laura herself posts these pictures, we will win. And we will get her to take them down. And you know why? Because they have copyright on their side. And she has privacy law on her side. And if you have a choice, and you don't know anything else, and someone gives you privacy law and they give you copyright law, take copyright law, because that gives you so much more protection. Now, I'm not trying to say that the law should protect things like it protects copyright. I think copyright law can be too excessive in a lot of cases. I don't think it's a perfect body of law. But the reason I invoke it is because I think that it demonstrates an important point. And that I often hear in privacy debates, people say, well, the information's out on the public. There's nothing we can do. It's just impossible to control information. The law really can't stop people from spreading or disseminating or using information in certain ways. So we have to adopt this very binary understanding of privacy, where either you have total control and you keep it secret, or you lose total control because it's out in the open. And the interesting thing about copyright laws, it illustrates no. You can have something that's out in the public, that's on a public website, but that you still have rights to control it. And so I think it illustrates the law. It is possible for the law to provide some regulation of control. Now, I don't think it should do identical to copyright. I don't think that all information is property and should be owned by the person. But I do think that the law should make further steps to giving people more rights of control of their information. And I think copyright law illustrates that that is possible, that the law could, if it wanted to, do this. And that the throwing up the arms of the law and saying it's just not going to work, I think we can look to copyright law and say, yes, there is a body of law that we could use when the law really wants to protect things. So I want to say a few words just to kind of conclude, because I want to spend a little bit of time fielding some of your questions and discussing this with you. I think gossip, rumor, shame, reputation, these have been issues that have existed with us since the dawn of civilization. And new technologies today are forcing us to really confront and address these issues once again. I think the future of reputation is here, and I don't think we're ready for it. I certainly don't think that the law is ready for it. But I think we really need to start thinking about this, because the consequences are profound. Thank you very much. So I'd be happy to take a bunch of anyone's questions. Yeah.
I appreciate this concept of copyright trumping privacy. I appreciate the concept of this, the idea of this concept of copyright trumping privacy. If I find myself involved in anything that might be webcast or put online, can I just say, by the way, this is copyrighted, and then go on? Or like if I see a camera at me and I start talking, can I just say, this speech is being copyrighted, go ahead and go on with whatever I'm about to say?
Well, you are being webcast right now, actually.
So that's what. By the way, this question is being copyrighted.
Well, I don't know enough if you could sort of copyright just a. You could certainly copyright your expression. So if you're here and the words that I say in the speech are going to be protected by copyright, I don't need to say it in order for it to be the case. Just like I can write a paper, post it online, I don't need to say that it's copyrighted for the copyright protection to exist in it. It does exist, regardless of whether I put the copyright symbol on it or not. And it basically exists whenever you have, original expression. And you can't copyright ideas, but you can copyright your expression. And so the way you would express things, the words you use, that could be copyrighted.
Follow-up is, what's to stop Dog Poop Girl or Star Wars Boy from saying that this is copyrightable expression? Stop blogging this.
Because she didn't take the picture. If I take your picture, guess who has copyright on that picture? I do, because I'm the one who created the picture. You have privacy rights in that picture. So the picture could reveal private facts about your life. You could sue for that. You could also sue for an appropriation of name or likeness, which is has a complicated kind of tortured history in the courts. You could say, look, I'm using your image to make a profit on your identity. But that tort is mostly successful with celebrities because of the way courts have read it. And so it's going to be a hard road for you to win under appropriation in certain cases unless I take your picture, unless you're Michael Jordan and I use you on a Wheaties box. It's going to be harder for you to really have much of an appropriation case, whereas with copyright, I have all sorts of protections in that photograph that I've taken. So it's just a better tool. And so a lot of the information that's put online, even if it's about you, it's expressed by other people. So I write a story about your private life. I own the copyright in my story, not you. Yeah.
I want to talk about the tort of defamation, specifically libel. And I'd like to know if you believe or if you're aware of somewhere where one can find information. Can bloggers be held liable civilly for defamatory comments? And there's two other parts of the question. How does one go about discovering their identity, if that's at all possible? And can a host website, not necessarily a website where it's the individual blogger's site, but say something big like a Ted Turner-owned something or other, be held liable as well for the defamatory comments of its bloggers? Because I know they want to hide behind the First Amendment.
Well, the answers are yes, yes, and no, basically. So to unpack that, the first question is, can a blogger be liable for defamation? Yes. If I write a defamatory statement about you, I can be liable, just like if I said it here today, just like if I published it in a newspaper, you can be liable directly for libelous statements. Now, what if I'm anonymous? What if I have an anonymous blog? I call myself Gossip Monger, and I start blogging about your personal life, and I start blogging about people in this room's personal life. And I say, ha, 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 no one knows who I am. It's true that to the world I am Gossip Monger and no one knows my real identity, but you can often trace who people are. There's a difference between anonymity and traceability. And a lot of people think, oh, if I just use a pseudonym, no one can get me. And the answer is no. You can, in fact, find out who someone is because you find out the IP address that's posting to the blog, and you probably have an internet account with somebody, and they have the IP address for that session, and they can track who you are. And there's a lot of other ways you can track and identify people who post online. Now, it is true that if you really are good and you use anonymizing software and you're very careful about covering your tracks, you can be anonymous online. But some good people can really sleuth you out and track you down in a lot of cases, and most people don't know how to be truly anonymous. So yes, you can sue. You sue the pseudonym. You sue gossip monger, and then if your suit can survive summary judgment or has certain a threshold standard, then the court will order the ISP to link it to your identity, and presto. Now the third question is, well, what about sites that host information? An example might be, let's say I have a blog, and I do have a blog, and people can comment on that blog. Anyone can comment. You guys can write a comment to my blog or any of the posts, and you can do so anonymously. You can do whatever. And suppose one of you decides to write a libelous statement against someone, or something invasive of privacy about somebody, or suppose you decide to load up to YouTube, a video of someone, taking a shower, and they want to sue YouTube for, hosting a video that was invasive of privacy, or someone wants to sue me for having the comment on my blog that someone else wrote that is libelous. And the answer is that I'm not liable for the speech of other people who put it on my site. I'm liable for what I say, but not for what they say. Now, there's a law called the Communications Decency Act, Section 230. This law immunizes websites, ISPs, blogs for content that others put on them. So it basically says if I have my blog and someone else posts libel on it, I'm immune. Go sue the blogger who posted it, but I'm immune from that. Now, I think that's fine as a general rule, but courts have interpreted Section 230 to go a step further. And the way they've interpreted it is in a very, I think, radically pro-free speech dimension, and that is as follows. Under defamation law, if I know that the speech is defamatory, I'm on notice that this is defamatory or invasive of privacy or whatever, and I then continue to distribute that information, then I can be liable. But CDA has been interpreted to, in fact, bar liability in that circumstance. So it could mean that someone posts a nude picture of you on a photography website. You call the photography website. You say, please take this down. It invades my privacy. They look at it and say, yep, it does. And guess what? We're not taking it down. We like it. And guess what? They're immune. Now, I think that's going too far, and I think that's very problematic. There's a whole breed of websites now that are gossip websites. One is called Juicy Campus. This is a website where people can, it solicits gossip from various college campuses, and people can post gossip about other students. And they basically say, look, we're not putting the information up ourselves, so Section 230 immunity for us. And as a result, they're facilitating gossip that way, and they've immunized themselves from suit because of this Section 230. And I think it's a license to be very irresponsible and to be non-responsive to people who claim that their information is harmed. And so I think that's where Section 230 goes too far, and I think should be cut back. So it's a very long answer to your three questions. Yeah.
Well, does Section 230 immunize both pecuniary liability and injunctive relief, or only pecuniary liability? So if you had one of these invasive photos posted, could you sue for an affirmative injunction to require its removal from the website?
Probably not. First of all, courts are very reluctant to grant injunctive relief, so typically you're going to have a much better chance trying to get damages, and then ultimately people would say, I'd rather take it down than continue to pay damages. Some courts will grant injunctive relief, but if you're immune, there's no real claim that you can claim like you should take it down. Why? I'm not doing anything wrong. There's no legal harm that I'm doing. And so I would think that Section 230 would it's to kick the case out of the court.
That's not true, though. If you are doing something wrong, there's simply no liability for it.
That might be I think you are. But nevertheless, I have yet to see a court with Section 230 hold that, okay, you're immune from any damages, but we're going to have this robust realm of injunctive relief that we're going to afford. And maybe that's a solution. Let's not have damages liability, and let's only have injunctive relief for that. But I think injunctive relief gets into some problems, especially with First Amendment, because it runs into prior restraint doctrine, which is even more protective of free speech than you get with after-the-fact liability.
It's not a prior restraint, it's a subsequent restraint.
Well, it depends, because some courts will say, look, you're continuing to express something, it's continuing to be up, you're by sort of taking that down and not removing that, sort of affirmatively removing that is one of the things with the blog, with the internet, is what constitutes the Speech Act and how far into the future does it go? Because I have that up on the blog. It's not like a publication where I can't just zap it out of existence like I can with a blog. I publish a book and there's something defamatory in the book. It's there. And I can be stopped from, it'd be hard, you can say, don't say that in the future. Now in a blog, yeah, I can zap it off and not say it in the future, but what if I keep it on? Am I still saying it into the future? It's a question that I don't think is necessarily answered. When does speech occur in a blog? Every time I keep that on or I keep a comment alive, am I speaking? Now, obviously, we have issues of statute of limitations. When does that apply? When does the Internet Speech Act end? And so on. So it raises a kind of very interesting nexus of questions. And even for prior restraints, I think you raise a good point. Well, maybe it's the case that once it's been said, prior restraint doctrines out of the picture, and we're only going to have, then injunctions are perfectly fine. And that would be a particular interpretation of prior restraint doctrine. Although I think courts get very, very wary. They get wary with liability, but they get very, very wary once we start talking about injunctive relief when it comes to speech. So we're into territory where we're even more, courts are even more concerned and more reluctant to do things.
Yeah. Somewhat following his question, has there been any cases of, Google Cache or Internet Archive where, there's stored websites going back 10 years or more? Have there been any cases of relief coming or injunctions being brought against those companies to take off, cache information? There could be a website that somebody deleted in year 2000, but it's still there. Has there been any cases?
I haven't seen many on the privacy basis. And the way Google will work is it basically says, we'll recrawl the website, and eventually it gets kicked out of the cache automatically if the other website takes it off. So Google Cache, for those of you who don't know what Google Cache is, Google crawls the internet and takes a snapshot of what's up there, and then it uses it to index the terms so when you do your searches. So even if I can take my website, I can write something about you, I can take it off my site, and you do a search, and it still will come up on Google, and Google has saved a copy in its cache. You can see an archived copy. And there's also something called the Internet Archive that does this as well. It archives the Internet, and so if I want to see older versions of things I wrote, you can go back into the Internet Archive. It's called the Wayback Machine. Now, the Internet Archive actually has a process where you can ask them, please take something down, please remove it, and they will remove it. Google basically says, look, we do all these sites, we can't remove everything. All you need to do is tell that site to put in a certain coding, which then tells us to recrawl it, because Google will crawl sites at a certain interval rate. Some sites it crawls every day. It's going to crawl major news, like CNN, it's going to crawl all the time. But for some obscure blog, it probably is going to crawl it every once in a while, and it might not know, oh, there's a new version, it's time to recrawl. But you can put in coding that tells Google, recrawl this site, and then it'll crawl it, and then that boots it out of the cache. But it depends on that website operator to do that. And Google's going to say, oh, it's their fault, they should do it. And I haven't seen any case that says, well, no, maybe Google should sort of affirmatively do this as well. If someone requests, they should have at least a process by which they'll recrawl at their request. I think Google's going to say, well, out of thousands of people want to recrawl, because everyone wants a recrawl, not for privacy problems, but for other things. They just want a more refreshing of our site in Google. And that's, I think, a problem they must be concerned about. Like, what about abuse? Because everyone's going to want to use that to game the system in Google. So I think it's an interesting set of issues, and I haven't seen anything on it yet. Yeah.
Owns the photographs that are taken to elicit medical care, or, for instance, an X-ray is owned by the patient, but the copies that are made, it seems, apparently are owned by the hospital.
Yeah, I don't know much about that.
I want to give you an example, a way-out example. I get at least once a week pictures of children with cleft palates, and it's a charity to try to get solicitation for care for these children so that they will not go through life so with the kinds of faces they have. If one of these children becomes a famous actress, suddenly that picture of her would have real value to someone. Who owns it?
Well, I still think that it's not clear. I really don't know the answer to that, because you might have certain understandings when it comes to pictures of patients that is not the same as just the ordinary taking of a photograph. That said, I still think there are going to be very strong protections against the hospital, whoever has the picture, from releasing it, because there are ethical rules that prevent hospitals and physicians and health care providers from disclosing personal information about patients. There are they can be sued for the breach of confidentiality tort, and that's where the U.S. tort is actually very strong, and in most states recognizes liability if a physician were to disclose information about a patient without a justifiable reason, i.e. to protect public health or to protect someone's safety. And so the patient would have, I think, very strong rights in that context to stop that photograph from being leaked out, and so they would have greater rights of control because they're in that medical relationship context. Once we get out of that relationship, then everything becomes much more murky, because we really don't have a good set of rules just to govern everyday friendships or spousal relationships and other relationships. We don't have that same application of the tort there. And so we're not going to have that same level of protection. But I think you get in a lot of trouble as a hospital or a doctor if you disclose those photographs. So you will have some protection. Yeah.
Any ideas about what can be done socially outside of the realm of the law to promote a more robust notion of trustworthiness, so that, especially because so many of the people involved are kids, and so many of the complicated cases that one could imagine involve kids, either kids broadcasting illegal or horribly embarrassing things of one another, or cases, I know of some where kids who they're not very old, they're 18, 17, and they're accused of sexual predation, and then they go on the web on those lists. How can there be a more robust notion of what it means either to trust one another or to be trustworthy, so that this can be changed for kids on the ground before it ever gets to the realm of parents or lawsuits and stuff like that?
Well, I think that's a very tough question, because we're dealing with changing norms, and in particular changing norms in teaching kids who are teenagers. Which is very difficult in and of itself to get them to listen to anything. But I think right now, very few parents or schools really have grappled with this problem, have thought about this problem. There's not a lot of education out there. There's not a lot of people who have experience in this. And so I think one thing is just education, that people should be aware of the consequences and at least warned or taught, and parents should be more involved and actually know if their children are having social network websites and what they're saying on them, so that they're involved. They know it's something that's important enough to be watching out after a little bit to make sure things don't get out of hand. I think the role the law really can do is kind of, to some extent, try to promote those norms and to try to create a sense of responsibility. But the law is limited to some extent in what it can do. It's very hard to do that, and I'm suggesting the law try to do that. Because at the end of the day, if norms don't change, if people don't get the sense this is something they're going to be doing responsibly, you really can't do a whole lot. And I think that's what makes the problem really tough. You have to hope that if we push the law in this direction, it'll make people get more educated, educate other people, be more responsible, and help kickstart this thing to happen. But to get sort of this norm change, is a very complex process. Law can only play a part to kind of nudge it in that direction, which is what I'm suggesting, a kind of modest way to nudge it. But at the end of the day, it's something that we haven't really figured out a good scientific way to kind of change norms, especially among teenagers who are not accustomed to really thinking in the long view, in the long-term view, about the consequences of what they're doing now. So that makes the problem even more difficult.
On that, we're going to wrap up, and I'm reminded, especially of the last question, of a comment that a user of Facebook made very recently in response to Facebook's attempt to change its system and provide almost instantaneous information and feedback to people who are connected to social networking sites. And the student of the child said, effectively, I expect my life to be translucent, but not transparent. And so part of what's happening here is educational, right? That people have to understand, as Professor Solove has tried to do today, the extent to which information and our reputations are going to be changed by the technology and the environment we're in. I'm reminded that I wanted to tell you that we have a reception immediately following this upstairs in what the law school calls Blackacre. And again, I'd like you to join me in thanking Professor Solove for his talk today.